Hello, everyone. My name is Chris Johnson. I'm a business lawyer and entrepreneur, and I'm going to talk to you about how to buy a business. A lot of people right now are talking about the silver tsunami. All these people that are the baby boomers essentially are retiring, and there's opportunities to buy their businesses, and they're not necessarily thinking about their exit plan. And so a savvy buyer can buy a business using, I think one of the buzzwords now is creative financing. Essentially, most of the time they're referring to seller financing, in which case you wouldn't have to put any money down to buy a business, but they're also looking at buying these businesses on more favorable terms than they would normally be able to purchase them for. Now, look, there's some very sophisticated buyers out there. There are companies out there that their whole existence is a roll-up strategy, meaning they're going to grow through acquisitions, and they have an acquisition plan. They're structured for acquisitions. They have the financial backing, and they're going to acquire a certain number of businesses, get to a certain level of revenue or EBITDA, and then they're going to sell to someone else. And usually they've identified that exit strategy as well. They have this all planned out beforehand before they go into doing it. And they typically have a business acquisition department, a department that helps with due diligence. Sometimes they have in-house attorneys. Oftentimes they use outside counsel, and they have people in the company that are able to examine, evaluate, and analyze transactions. So why do I tell you that? I do represent some of those people, but I also represent people that aren't as sophisticated. Someone perhaps like myself, because I'm not that sophisticated. I don't have that structure set up, but that is going to acquire another business, which I also have done. And I do continue to do occasionally when the opportunity arises. So what do we need to know about buying business? So I want to give a brief overview of what this really looks like to help demystify the process. So if you go to buy a business or you're serious about looking at buying a business, then you at least have the cliff notes of what it's all about. First of all, you have to look at what kind of business you want, or otherwise establish the criteria for the business. When I talk to someone, there's like, I want to buy businesses. And I'm like, oh, great. What kind of businesses do you want to buy? And they're like, any kind of businesses. I'm like, all right, okay, that's nice. But if they do say any kind of business, but it has to have an EBITDA over a certain level, okay, that's way better. If I hear, I want to buy this type of business with this level of EBITDA, and the seller principal looks like this is the exact type of acquisition we want to make, and this is how we're going to integrate them into the existing business. That's what I really like to hear. So what do buyers look for? Some of the criteria might be self-sufficiency, meaning the business is able to run on its own. And I've talked about this in other videos. People that buy a business typically do not want to buy a job. There's no value in that. They can go on Indeed, they can apply for a job, they can work for someone else. So if you're just going to shell out money to buy a job, it doesn't make a whole lot of sense from a buyer's perspective. A buyer wants to actually buy a business, a real business, a business that operates on its own. Typically, this looks like there's some type of mid-level management structure, organization in place where the CEO of the company is not operating in the day-to-day. They're just not doing that. They're doing more the CEO functions of a company, more the ownership level of a company. This is attractive for buyers. Buyers also might be looking for intellectual property. Intellectual property makes a business more valuable. When I say intellectual property, I'm using that broadly. It could be actual legally intellectual property, such as patents, trademarks, copyrights, but I'm also referring to intellectual property as the business has devoted time and resources to creating stuff, brand materials, employee handbooks, policies, procedures, contracts, all the stuff that when you're in like a Fortune 500 company, they have all these things. If those things are already prepared and the buyer's buying into the business, it makes it more valuable because then they don't have to go in and do it, right? And then there's also technological assets, and I'm going to list this separately from intellectual property. It really is, but oftentimes there are strategic acquisitions, and you'll see this with tech companies, or you'll see it with other companies where they strategically want to buy some technology. And in that case, and this is one of the reasons tech is so popular, because people will pay a higher value if there's some kind of technology that's very useful to the buyer. So there's different reasons for making an acquisition. Sometimes it is purely as an investment. Sometimes it's more strategic to add a certain market position to the business. Sometimes it's strategic in the sense that they want to maybe take out a competitor or tack on some kind of technology that the company can then leverage. And I haven't listed every reason, but I've just listed some of the reasons that a buyer might buy a business. So how do you find a business once you know what kind of business you're looking for? There's listings out there. I haven't found them to be that effective, but they're free and you can look at them online. You can use a business broker. They can be very effective. And I've worked with some very good business brokers. I've worked with some very bad business brokers too. In this case, I would get a referral from someone before working with any business broker, someone that's worked with that business broker before, or maybe an attorney that has, or an accountant that has, something along those lines. Business brokers don't have to be licensed. There's really no threshold. Anyone can go out there and say, I broker businesses, and I've seen a lot of garbage, and I've seen a lot of misrepresentation and really bad acts, unfortunately, in the industry, but it can be a very effective way to find a business. And then there's some of the more savvy marketing techniques I've seen for finding businesses. So think like that. So there's a wholesaler looking for real estate. They might use technology and they'll cull through all the things themselves. So I'm thinking along those lines. So going through directories and reaching out to older business owners. They may not be on LinkedIn. So how would you reach them? Maybe just by sending them a letter or finding their email address or something like that, so you can get in front of them and say, hey, have you ever thought about selling your business? So that involves some work to actually locate that business. But those are just some of the ways that you can do that. Obviously, there's also leveraging industry connections and people you know and referrals and just putting it out there in the universe. Hey, I want to buy a business. So now you have found this business. So how do you value it? Well, before you find it, you should probably know the valuation. I tell people, either whether you're looking to buy or sell a business, one of the first things you should do is know how you're going to value the business. And what I mean by that is back of the napkin, just a simple calculation. This depends on the type of the business. Typically, businesses are valued on a multiple of EBITDA, which is earnings before interest, taxes, and appreciation, which is essentially profit, or a multiple of revenue. Okay. Well, how is this type of business valued? Well, it all depends on that type of business. And you'll typically have a range in the valuation. So maybe a 3 times 5 multiple or of EBITDA, or a 5 to 8 multiple of EBITDA. And then you can add on other factors, like I mentioned before, such as if there's technology or other things that make this company more valuable to you and you're just willing to pay more for the company, that might be a factor. Once you know back in the napkin math, there's also business appraisers out there. So before you go into this process, you should get hooked up with a good business appraiser. I find there's different levels of appraisals. There's kind of the more simple appraisal, and then there's the more complete appraisal. And you can order one of those depending on where you're at in the process. So it can help you evaluate what you're willing to pay for this business. And remember, depending on how you structure the deal, can also sweeten it for you with respect to the terms of the payment, right? Doesn't have to be 100% cash up front. Could be an SBA loan, could be seller financing, it could be other things like that. And those are considerations when determining how much you're willing to pay for a business. Once you start the discussions, one of the first things that's going to happen is you will enter into an NDA. You might even propose it. I don't think that's a bad thing. It's super, super standard. And what I mean by NDA is a non-disclosure agreement, essentially a confidentiality agreement. So the buyer can propose it, the seller could propose it. Typically, the party more seriously consider the transaction, they will enter into the NDA. So when you're the buyer, there's certain things that you're going to want in the NDA. I like to limit the time frame under which the information is confidential. That way, either some tail to potential liability if you go out and do something and then the party's like, oh, it looks like you stole my confidential information. If this was like 5 years later, they can't do it, right? And as a seller, it's the other way. They're going to want really no term limit to that. There's other things that you can massage into the NDA to make it more buyer friendly. This is seen as a very templated document by many people. It isn't necessarily so. And it is important to have an attorney review the NDA because you can sneak things in that a non-attorney can't really see. They can't tell that it's really there. And so I think it's important to have an attorney analyze the NDA before entering into it. Once you enter into the NDA, then the seller feels more comfortable exchanging some basic information with the buyer. So then the buyer can further determine whether they're interested in purchasing the business. So this will be some financial statements, other things about the business, questions about how it's run, salary, payroll, things like that. So the buyer can evaluate the business. Once the buyer feels comfortable that they want this company, then they will submit an LOI, which is a letter of intent, or a term sheet, which is the same thing essentially as a letter of intent. It's just in a different format, over to the seller. And here are some things that you're going to want in this letter of intent. As the buyer, you will want a provision where the seller has to take the business off the market, or if it's not on the market, just not offer for sale to anyone else. It's an exclusivity provision where the buyer has a certain period of time where they can just focus on the business because they don't want to go through this process, conduct due diligence, and then the seller just goes ahead and sells it out from under them. So that's one of the more important provisions. Also, if the buyer wants certain provisions of the letter of intent to be binding, they can state this in the letter of intent because typically letters of intent are not binding. They're really psychologically binding. Once the parties narrow down these terms of the agreement, even if it's not binding, if one of them deviates substantially from one of the terms without having a good reason to do so, it will upset the other side and it may bust the whole deal. So they are psychologically binding, even though they're not typically legally binding. But if there's some things in there that are ultra, ultra, ultra important to you, then you as the buyer should make them binding. One of the things that I'm thinking of right now is that the seller would be subject to a non-compete for a certain period of years within a certain geographic area. And the reason that this would be important to a buyer is because it would be catastrophic for a buyer to pay millions of dollars to a seller thinking that the seller is just going to retire from the business, and then the seller pockets the money and starts a competing company against the buyer. That would destroy the benefit of the bargain. The business wouldn't be as valuable to the buyer. So in many instances, the inclusion of a non-compete is what makes the business as valuable as it is, at least in the buyer's mind. It ties up that goodwill, and it's really important to have in the process. And non-competes are under attack. The FTC are attacking non-competes, but even the FTC carved out an exception for sellers of businesses because it's really important. Otherwise, I think it would, in my opinion, frustrate the sale of businesses. There's other terms that you can discuss. Payment terms are going to be really important. There's a lot out there in the market, like don't put any money down. You don't have to put any money down. I'm not a big believer in that because I think sellers pretty much sniff that out. But if you're able to do 100% seller financing, good for you. If you're able to do an SBA loan, that's great too. But here's the rule, and this is why they say don't put money down. The buyer wants to relinquish the least amount of cash possible, whereas the seller, on the other hand, wants to receive as much cash as possible. So in other words, the seller is going to want one lump sum. If the business is being sold for $1 million, the seller is going to want $1 million on the date of closing. And it takes the risk away from the seller. The seller can just walk away, take their $1 million and be done. The buyer, on the other hand, wants to defer the payment of the price. The buyer would want to defer all of it through seller financing, through a note that defers the risk. The business doesn't turn out as well as the buyer hoped it would turn out. The buyer, typically, it's better for them not to personally guarantee this note. It's better for the buyer not to have a security agreement included within this note. The buyer can also defer the payment of a purchase price through what is called an earn-out. This is also akin to like a performance bonus. So the buyer could say, your business is worth $2 million. So here's what I'm going to do. I'm going to pay you $1 million, and then I'll provide $2 million in performance bonuses. So they'll phrase it like a win-win. And that's good for the buyer because that mitigates the risk that the business turns out to be not as good as the buyer hoped it would. And it's good for the buyer because then the seller is motivated to hit certain key performance metrics, because that's how the earnouts are typically structured, is if seller gets the business, because the seller is going to stay on the company afterwards and help transition it over to the buyer over a period of years. If the seller hits a certain revenue level within this year, they get an earnout. If they hit a certain revenue level with this year, they get an earnout. So the terms of the earnout are very important, and it's very important to negotiate these and have these clearly stated. Finally, I want to go over just the general structure of how you can structure an acquisition. Buyers typically want an asset sale. An asset sale is where the seller sells the assets of the company to the buyer. The buyer buys those assets through a new entity that the buyer sets up. So why does a buyer want to do this? Typically, a buyer wants to do this because there are some tax benefits, but more important, because of the liability protections. It's like a fresh start. It's a clean start where they don't have to worry about any liabilities that might be lingering in that original entity. There's also a stock sale where the buyer can purchase all the ownership interests of the seller or a portion of the ownership interests of the seller. And so typically transactions are structured as either an asset sale or a stock sale. Once that LOI is signed, this is where the attorneys are really going to get involved. They're really going to jump into this deal, and they're going to start working on the definitive documents. It's customary, not necessarily a requirement, but it's customary for the buyer to prepare the definitive documents and send the first draft over to the seller. So buyers should be prepared to have their attorney ready to do these things if they're serious about entering into a transaction. I'm not going to go over all the definitive documents, but I will say that the purchase agreements, the main parts are going to be the reps and warranties, the indemnification, the payment terms, the purchase price. The reps and warranties and the indemnification are oftentimes the most confusing and least understood by the parties. They seem like they're not very important, but I will say they are important for two reasons. One, they actually help define the scope of the deal. I can't tell you how many times while the attorneys are in the process of negotiating the reps and warranties and what the parties are willing to agree to, that the buyer discovers, wow, this business isn't what the seller originally told me it was. So it's a kind of due diligence. Through the process of making the seller promise certain things, the seller really admits that certain things aren't true because they can't promise these things. And that's what reps and warranties are. They're contractual promises as to certain conditions, so you understand what this company is or other things involving the transaction. Indemnification is like an insurance policy protecting against third-party claims. Those are important provisions to protect either side, and they help define the transaction as well. I've discussed the pieces of the purchase agreements in more details in a presentation called Anatomy of a Corporate Transaction. You can look there if you want to hear about these things in further detail. The other definitive documents might be the employment agreement, and depending on the complexity of the transaction, you can have 50 additional documents where you have resolutions and other things. The promissory note, if there's seller financing, the security agreement, maybe if there's seller financing, other documents like that are just as important as the purchase agreement. And actually, I have seen transactions where 90% of the time was on negotiating the terms of the employment agreement. Because remember, oftentimes, this is a seller principal of a company trying to sell their company to the buyer. And the buyer wants the seller principal to stay on for a period of time. So the seller principal is used to being the boss. They're used to being the owner of the company and doing what they want to do. Well, they're about to turn into an employee. And that makes them uncomfortable, understandably so. And so they want to carefully look at the terms of the employment agreement. And I've seen a lot of disputes come up just from the fact that the seller principal becomes an employee and finds out, I don't really like being an employee. They just can't take it. And then it creates distress and disputes later on, and the transaction sours post-closing. The transaction's not fully integrated for that reason. So I'll jump to post-closing and closing. Closing is not nearly as hard as any of the other steps. Closing really just involves typically pre-signing the documents, having an attorney hold it in trust, releasing them on the day of closing, wiring the money, maybe doing a closing call, which I think is nice, especially if you're the buyer, because you can make sure all the wiring instructions are correct. And this is your opportunity to talk to the seller. Remember, the attorneys have been talking to each other for maybe a month, 2 months. Now the parties can talk to each other directly and be like, you know what? All this nonsense is behind us. There might have been some negotiations, some butthurt between the parties. Now they can be like, you know what? I'm excited about this transaction. We're moving forward. And I think that's a really, really nice way to integrate the seller's business into the buyer's business is by doing this closing call. There's also going to be post-closing items. The attorneys will typically work on those, make sure that all the post-closing items are done. And I'm not going to go into detail on this, but integration of the transaction is just important, maybe if not even more important than the transaction itself. So one of the hardest things for a seller is knowing when to tell their employees, because they don't want to scare their employees. They love their employees. Sellers view the company as their baby. And oftentimes it's the thing that they ask me the most. What should I tell the employees? When should I tell them? Who should I tell? So typically I tell sellers only to tell the people that have to know in order for this transaction to move forward. And with respect to those people, you can offer them some kind of incentive to incentivize them if this transaction moves forward and goes well, just for their extra efforts. Now that the transaction is closed, now's when the seller wants to tell the employees. Well, the buyer needs to be there. And the buyer, remember, is going to be developing this relationship with the seller the whole time. They're going to be learning the business, and the buyer needs to be very proactive about being involved in the announcement, how it's phrased to the employees, letting the employees know that this is exciting. This is an opportunity. This is our strategy for growth. A lot of it's how it's phrased as a positive thing, as an opportunity. And then it's just a matter of proactively integrating systems, removing redundancies, other things like that, that again, I'm not going to get into because these are business operation things, not legal things. So I hope that this was helpful to you. This wasn't intended to cover every aspect of buying a business. It's really a primer. It's something that you can watch and really understand the cliff notes of how to buy a business, just to demystify it, just so it's not as complicated. And then you can educate yourself more and dive into the weeds, look at some of our other videos to learn some of the nuances of how to buy a business. There's a lot of materials out there. There's a lot of good resources. And I'm confident that you'll be able to buy a business. It's not that bad, but it's definitely harder than buying a house. With that, I wish you luck, and I hope you enjoyed this presentation.